Right out the gate, we're diving into a drug paraphernalia charge. Quick legal note. Paraphernalia isn't the drugs themselves, it's the stuff used to consume them. Pipes, syringes, even certain baggies. And yes, it's a misdemeanor, but don't let the word fool you. 90 days behind bars is no small deal. Imagine losing an entire summer over a lighter or a pipe.
Pittsfield Township, specifically that being Washington Avenue, that you did at that time had possession of drug paraphernalia. You understand that, sir?
No, I don't, sir.
Pardon?
I have no idea what this is about with paraphernalia.
Okay, so have a complaint that alleges that on the date I just said, at that location, they're alleging that you were in possession of drug paraphernalia. I'm not asking, not saying whether or not you did it. You understand what you were charged with?
Yeah,
Do you understand what you were charged with?
I do today, yeah, actually.
Okay.
I was being charged.
And that is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, and the court could order any substance abuse treatment. You understand that, sir?
Yes, yeah, sure.
You understand that?
Yeah.
Do you wish to be represented by an attorney?
Absolutely.
At this point,
Catch that? The judge isn't just talking about fines. Courts can also order substance abuse treatment. Translation: even if you dodge jail, you might find yourself in mandatory counseling. Here's the big question for you. Do you think treatment should be punishment, or is it a second chance?
This is a public defender case. And then somehow or another, they'll make the magical switch somehow or another.
For the time being, Assistant Public Defender Natalie Davis, and on behalf of Ms. Hardy, we would waive any further reading. My client stands mute and asks that a not guilty plea be entered, and we would ask for an adjourned pre-trial date.
Then have a waive formal reading standing mute. The court will enter a not guilty plea. Pre-trial in this matter will be adjourned. Did they say how fast they can make things happen? They can make it happen, brother.
They didn't say, Your Honor. I don't know.
All right. Why don't September 17th, will that work?
Works for me, Your Honor.
All right. I'll adjourn it out to September 17th, 2025. And as to your other matter, you want me to adjourn it to that same day?
Yes, please, Your Honor.
All right, so I'll adjourn this one to September 17th. Let me set bond conditions on me. Pardon? I don't know that that's a violation, is it? So we got a problem. They've listed it as a progress report, but on August 1st, did a 10 panel, or was supposed to do a 10 panel. He missed his test.
Here we go. Court-ordered drug testing. The Achilles heel for so many defendants. Missing a test is often treated the same as failing one. Why? Because to the court, both suggest the same thing. You might be using. It's basically guilty until proven clean.
Stated he didn't have money to do it at the time. On August 4th, he did a 10 panel. Problem is, he came up positive for amphetamines. And he denied having any current prescriptions that would have shown that.
You guys speak with me?
Pardon?
I called them and I asked them what I should do if I should come in and test on the first. And they told me, don't worry about it, and call back the next day. And I called back, and then I think the days are messed up. The moment I went and saw them, I went and tested.
What do you mean the days are messed up?
Because you said that from the 1st and the 4th. And it was only the day after that I'd spoken with them.
I'm indicating what this says. I wasn't there. Okay?
Yeah.
So I'm telling what it says. I am not so much concerned about the dates. I am more concerned about why you have amphetamines in your system.
I've been taking arose since I was 7 years old.
Did you tell them that you have a prescription? Do you have a prescription for it?
I lost my prescription, sir.
Pardon?
I lost my prescription. I had to change doctors.
Now, this is fascinating. He's claiming a history with prescription medication, amphetamines, likely ADHD meds like Adderall. Here's the legal snag. Without an active prescription in hand, the court only sees a failed drug screen. Paperwork is power. No prescription, no defense.
Me and him got into it. I even have a doctor's note from him saying that you can no longer be my, prescriber. Complicated story. Me and him got into it.
So you don't have a prescription?
No, I no longer have a primary care physician.
All right. Here's what I'm going to do. Sometime between now and the 17th, he needs to get back on and have his testing as he's supposed to have it. I'm not going to sit up here and argue with him tonight. Because I don't know, he knows what he's eating. I don't want to see those amphetamines unless he has a prescription in the system. Otherwise, I'm just going to make it real clear to you. I'll revoke your bond and you'll sit in jail until we get this thing done.
Okay.
Am I clear on that?
Yeah, I was just saying he's no longer prescribing me.
Am I clear?
Yes, sir.
I don't really need any more language from you.
Yes, Your Honor.
This bond in this case at this time will be set as $10,000 personal recognizance, a lower standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or illegal drug use, no possession of any weapons. I will sign a new community corrections order. I want him for testing. I want him tested once a week. All right. Thank you.
Thank you, Your Honor.
Assistant Public Defender Alexis serves on behalf of Mr. Thurman, who's approaching.
Olin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him. He, in a nutshell, has a place which he can be released to. However, his release to that place would be in violation of his current bond conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release.
This is where things get sticky. Housing restrictions on bond conditions often clash with reality. Imagine being legally homeless because every available couch violates a court order. Do you side with the rule book or the human reality? Let me know in the comments. Should judges bend the rules here or stay strict?
His contact with his own children of that other relationship is only supervised, right? So and I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that. Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm gonna do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions. When I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions in this case. I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3 o'clock block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay.
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock. My last.
Assistant Public Defender Alexis Jefferson on behalf of Mr. Thurman.
All right. And this is a recall. Were we able to make any progress?
Your Honor, I believe I will be renewing my request to allow him to be tethered to his mother's children's house. So it is my understanding that allowing him to stay there would not be a violation of his current bond conditions because he is allowed to have supervised visitation with those children. And at this time, he will always be supervised.
Well, no. Because as I understand the bond conditions, he's not to have any contact with any children. Was the exception to that were the children that were the alleged victims in this case.
No.
Your Honor, if I may clarify, I don't know if this was entirely clear earlier. The alleged minors involved in this case are not actually Mr. Thurman's children. Those are the
right. Correct.
Children. He does not share those.
You're right. I misspoke. But he wasn't to have any contact with any children. The two other children, there was an exception for supervised visitation.
Correct. And Your Honor, my argument is that that is what he'd be partaking in by residing in that home. There would always be another individual present in that household. The children's mother takes the children to her parents' house during the day while she's at work. She picks up those kids, brings them home. Mr. Thurman would be obviously home by himself without the kids there. They would be at the parents' house, the grandparents' house, and then the kids would return with the mother. So the mother would always be present during those interactions.
On the record, we would be objecting to that, given the fact that we can't make sure that that happens all the time. And I would have great concerns of him being around children and living in a residence with the children, given the facts of the case. We would be objecting for that reason.
And Your Honor, respectfully, even with the condition that he was allowed to have supervised visitation, there'd be no way to guarantee that that was taking place in the first place either. Your Honor, all this is being based off of right now is a 4-page police report. We did just receive some media discovery. I believe there's more to come based on a search warrant, but all of the information I have doesn't show that he's a danger to children at this time, especially his own children. Again, Your Honor, the children's mother is present in the court. She is willing to attest that she is perfectly okay with this arrangement, not feel unsafe leaving or having Mr. Thurman around their children.
Your Honor, I just have concerns given the facts of the case, even though it's much needed police report, we have a search warrant coming, but the facts of this case are that he put a camera in the bathroom that recorded the victim, her brother, and her children. And he sent those videos, including the children, to their father and other family members and other people. And the videos were of them using the restroom. I mean,
Plot twist. We're not just talking drug paraphernalia anymore. This case just escalated to hidden cameras, alleged recordings of minors, and distribution of private images. This isn't a misdemeanor world now. These are felonies that could follow someone for life. Notice how the defense leans on technicalities, while the prosecution zeroes in on the disturbing details.
The insurance victim said that he admitted to her over text that he had more images, and when she confronted him about this, it became physical, and he was grabbing her necklace, breaking it, bit her arm, scratched her. And I mean, I have concerns given that this case does include surveilling children and sending those images to other people.
And Your Honor, without getting too much into the facts of the case, it's my understanding that Mr. Thurman filed his own police report a week prior to this police report being filed involving the complaining witness. He did provide a copy of that police report to me, and we do have that in our files. If Your Honor is unable to let him reside with at the home of his mom.
I passed this matter so you could find alternative arrangements. I've heard all of this.
And Your Honor, those are alternative.
The way that it's going to work. Either he finds alternative arrangements or he's going back into custody.
And Your Honor, those other alternative arrangements, the only thing they were able to work out is putting Mr. Thurman up into a motel. They do have a location picked out, and they have confirmed that there is rooms available at that location.
Then I'm not going to have a problem with that either. Is that what he's going to do?
If Your Honor is not letting him...
I am not. I think I made my position real clear when we were at the bench. And I think my face, if not tone, is making it very clear as to my interpretation of this order. And no matter how many times someone goes to say it, the crux of the order is he is not to be around children. There are two exceptions. I'm not creating other exceptions.
And Your Honor, we would not object to the motel.
Your Honor, then I believe at that time that is what Mr. Thurman will be proceeding with.
We'll need that. He'll need to submit that address of the motel within 24 hours to the court and to community corrections. Then he can do that. And you're requesting an adjournment of these proceedings?
Yes, Your Honor. I'd be asking for the closest possible date.
The what?
The closest possible date that Your Honor can accommodate.
August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. And